What if the very first court hearing after your arrest could decide whether you face a trial or walk free? The preliminary hearing is your first real chance to fight back, but most people don't even know what it means or why it could save your future. Missing this critical step can lead to devastating consequences. Don't let confusion or fear trap you in the system. Stay with us to uncover what a preliminary hearing really is, why it matters, and how it could be the key to your defense. Don't miss out. Your freedom could depend on it! What is it? A preliminary hearing is an important early step in the criminal justice process. It happens after you are arrested and arraigned, but before a full trial. The main purpose of the preliminary hearing is to decide if there is enough evidence to move forward with your case. The judge listens to the prosecutor's evidence and decides whether there is a prima facie case against you. This means the judge checks if there is enough proof that a crime was committed and that you are likely the person who did it. At this hearing, the focus is not on proving guilt or innocence. It is simply to see if the case should continue. The hearing is usually held within 7 to 10 days after your arraignment. It is a chance for your attorney to challenge the evidence and for you to understand what the government is accusing you of. If the judge finds there is not enough evidence, the charges may be dismissed. But if there is enough evidence, your case will move forward to the next steps, like a formal arraignment and trial preparation. Understanding the preliminary hearing helps you be better prepared for your case and protects your rights early on. Purpose. The purpose of a preliminary hearing is to protect your rights by making sure the government has enough evidence to charge you with a crime before your case goes to trial. It is not a full trial where guilt or innocence is decided. Instead, it is a quick check by the judge to see if there is enough proof to believe you committed the crime. This proof is called prima facie evidence, meaning the judge must see enough facts that a reasonable person would believe a crime occurred and that you are likely the person responsible. This hearing prevents cases without enough evidence from wasting time in court. It also gives your attorney a chance to hear what the prosecution's evidence is and to begin building a defense. The preliminary hearing allows the judge to filter out weak cases early, so only those with real evidence move forward. Remember, if the judge decides there isn't enough evidence, your charges can be dismissed. That's why this hearing is so important. It protects innocent people from facing unfair trials and unnecessary stress, while also giving the prosecution a fair chance to prove their case. When it happens, a preliminary hearing usually happens soon after your arraignment, typically within 7 to 10 days. After you are arrested and your charges are read in court during arraignment, the judge sets a date for this hearing. The purpose is to quickly determine whether your case has enough evidence to proceed. This hearing is one of the first chances you get to hear what the prosecution plans to prove against you. It is important because it moves the case from the initial charge stage toward trial or dismissal. Timing matters because the court wants to move cases efficiently while protecting your rights. If your case lacks sufficient evidence, the hearing can stop the process early, saving you time and stress. If the judge finds enough evidence, your case moves forward to a formal arraignment, where you will receive official charges and prepare for trial or plea negotiations. Knowing when this hearing happens helps you and your attorney prepare and respond quickly. It is a key step that sets the path for everything that follows in your case. Who is there? At a preliminary hearing, the main people present are the judge, the prosecutor, your defense attorney, and you, the defendant. The judge oversees the hearing and listens to the evidence to decide if the case should continue. The prosecutor represents the government and presents evidence to show that there is enough proof to charge you with a crime. Your defense attorney is there to protect your rights, challenge the evidence, and argue if the evidence is weak or incomplete. You may also attend the hearing to hear the charges against you and to understand the case better. Sometimes witnesses or police officers may be called to testify, but not always. The hearing is generally less formal than a trial, and it focuses only on whether there is enough evidence to proceed, not on deciding guilt or innocence. It's important to have a skilled attorney present who knows how to question evidence and protect your interests during this crucial stage. Their role can make a big difference in how your case moves forward. Evidence needed. At a preliminary hearing, the prosecutor must present enough evidence to show there is a reasonable belief that a crime was committed and that you likely committed it. This is called prima facie evidence. It is not the same as proof beyond a reasonable doubt needed at a trial, but it must be enough to justify continuing the case. The evidence can include police reports, witness statements, physical evidence, or testimony from officers or other witnesses. However, this is a limited presentation, only enough to convince the judge that the case is worth pursuing. Your attorney can challenge this evidence by pointing out weaknesses, inconsistencies, or lack of proof. The goal is to show the judge that the prosecution's case is weak or incomplete. If the judge decides the evidence is not strong enough, the charges can be dismissed. But if the evidence meets the standard, the case moves forward to the formal arraignment and eventually to trial or plea negotiations. Understanding the type and strength of evidence needed helps you and your lawyer prepare the best defense possible. Your rights. During a preliminary hearing, you have important rights designed to protect you. First, you have the right to be represented by an attorney. If you cannot afford one, the court can appoint a public defender to help you. Your lawyer will be there to protect your interests and challenge the prosecution's evidence. You also have the right to be present at the hearing so you can hear the charges and the evidence against you. It's important to attend because this is when your case is officially reviewed. Additionally, you have the right to remain silent and not testify if you choose, as this hearing is not a trial. The judge's role is to decide if the case should continue, not to determine guilt or innocence. You can also expect your lawyer to argue on your behalf if the evidence is weak or if the prosecution has not met its burden. Knowing and exercising your rights during this stage can help protect you from unfair treatment and keep your case on the right path. Why it matters? The preliminary hearing is a crucial step because it protects your rights and stops weak cases early. It acts as a filter to make sure the government has enough evidence before your case moves forward to trial. Without this hearing, people might face long, costly trials even if there isn't enough proof against them. This hearing also gives you and your attorney a chance to hear the government's evidence and prepare your defense. It can reveal weaknesses or mistakes in the prosecution's case, which might lead to charges being reduced or dismissed. If the judge decides there is enough evidence, your case continues, and you will move on to the formal arraignment and trial preparation. But if the evidence is weak, the charges can be dropped, saving you from unnecessary legal battles. In short, the preliminary hearing matters because it helps protect innocent people, ensures fairness, and sets the stage for how your case will proceed. Being prepared and understanding this step is key to fighting your charges effectively. Thanks for watching! If you want to protect your rights and understand every step after an arrest, hit that subscribe button now. What do you think is the most important part of a preliminary hearing? And how would you prepare if it was your case? Share your thoughts in the comments below. And don't miss our next video. What is a plea deal? And should you take one? It could change everything about how you handle a criminal charge. Stay informed, stay prepared!